Be seated, everyone. Okay, welcome. This is case number civil 2026-028371, preliminary injunction hearing. Let's get everybody's names on the record, please.
Stephanie Zink, plaintiff.
Thank you.
Jeffrey Zink, plaintiff.
Thank you.
Good morning, Your Honor. Erin Sweeney, counsel for defense.
Thank you. Are we all ready to proceed?
Yes, Your Honor, defense is.
Yes, Your Honor, plaintiffs are.
Okay. We've got 3 hours. That means 80 minutes a side. I'll keep track of that. And Mr. Ms. Zink, you can call your first witness.
Your Honor, before we begin,
So when I said, are you all ready to proceed? That was my invitation for before we begin stuff. So please.
I apologize, Your Honor. I did file a motion to dismiss on August 3rd. I believe the motion to dismiss does impact the scope of what we get into at this hearing. So I did want to preliminarily address it on the record.
Yeah, I have not seen the motion to dismiss because the time for briefing hasn't completed. Is there something you want to talk about briefly about it?
Yes, Your Honor, I do believe the time for briefing would have been completed. It would have been 10 days. Time for response would have been August 13th, I believe, unless I'm incorrect.
Let me look at your motion.
Yes,
Your Honor, I'd like to point out that she mentioned the provision of 12B6 in her motion to dismiss. That effectively changes that motion to a motion for summary judgment. That entails a 30-day.
I'm going to stop you. You don't get 30 days to respond to a 12B6 motion. You get the
It's
standard.
Rule 56.
Get the standard, correct. You get the standard 10 days plus mailing, which
Plus mail.
to my knowledge hasn't passed yet. So I've not ruled on this motion, but if there's something you want to say about it, go ahead. I'd like to spend the time on what we have to deal with today and not get distracted on little procedural stuff. So tell me what you're going to argue.
Your Honor, the big issue is that the lender has not been named a defendant in this case. I previously addressed this at the TRO hearing on July 20th, that an adequate remedy would have been for the plaintiffs to issue a summons and serve process on the lender. They have not done so. Under ARS 33-807.
Lender the beneficiary under the deed of trust?
Yes, Your Honor.
And so that's not Regions Bank?
It is. They have not had a summons issued on them, or have they been served?
I'm sorry, they're named, they haven't been served.
A summons has not even been issued. There's no process, and although also there's insufficient service of process.
Okay, fair enough. Thank you.
I would like to point out that I didn't get a chance.
Ma'am, I'll call on you when it's time to talk, okay?
All right.
This is not a free-for-all. We're not going to just talk whenever we feel like it. I'm denying the motion without prejudice. You can file your response to the motion, and I'll rule on the motion when it's briefed. I'm happy to hear arguments about it in as much as it affects today's hearing, okay?
Your Honor, I do want to bring up the second part of that, the issue why the lender not being named a party is under ARS 33-807E. Unless the plaintiffs have alleged a specific breach of a foreclosure trustee duty, then it's mandatory that we are dismissed immediately from the lawsuit. If defendant ZBS is immediately dismissible, then there are no defendants in this case.
All right, thank you.
Thank you.
I'm denying the motion without prejudice actually, I'm not denying the motion. I'm declining to rule on the motion today because we've got a preliminary injunction hearing. Ma'am, is there something you need to add to that?
Yes, what I wanted to bring up is when I spoke to Regions Bank prior to even filing the complaint, I asked them specifically who I should serve if we chose to go down the path of filing a complaint. And I was specifically told that I should serve ZBS Law as they were the successor trustee.
Okay, thank you. You ready to call your first witness?
Yep, that would be me.
Thank you. Come on up, please. No, on the witness stand, please.
Oh, okay. Well, I can't question myself.
You can't question yourself. We do this all the time. I'm going to have you testify.
Okay.
When you're done testifying, then Ms. Sweeney can ask you questions, okay?
Okay.
And before you sit, we'll have you sworn in as a witness, please. Raise your right hand.
You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, be seated, please. Folks, I'll tell you, I take notes on my computer, so I'll be kind of focused here and tapping, and I apologize for that. All right, ma'am, whenever you're ready.
Okay, just want to bring to the court's attention that when we appeared at the temporary restraining order hearing virtually, you asked defendants to please provide proof that we needed to serve Regions. She has in fact done so. However, that contradicts the instructions that I was given when I called Regions to address the issue of filing a complaint against them.
Overruled. Go ahead.
Also, you asked defense counsel to provide whether or not ZBS Law had been given permission from Freddie Mac, who is the holder of the note, whether or not they had permission to initiate a trustee sale on our home. And that did not happen.
Hope you're not waiting for me. This is
It
your
was. I thought you were going to comment on.
Ma'am, maybe I should have started this. I am not going to lead this case. This is your case.
Okay.
You get to testify.
Okay.
When you make statements, I'm not making comments.
Okay.
Just give me your testimony.
I did bring a copy of Rule 12 as well as Rule 56 that outlines that a 12B6 provision is treated as a motion for summary judgment. If you'd like to have copies of that.
I'm familiar with those